Good evening and welcome to Know Your Rights. I am your host, Khadija Usher. On our show, you hear directly from attorneys who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. Tonight, we will be discussing your rights when engaging an attorney. You can watch us live on Channel 7 or on Facebook at Colorblind Multimedia Productions. You can also participate in the conversation by posting your comments or question on our Facebook page. Joining us tonight to discuss this topic is attorney Priscilla Banner. Good evening and welcome, Priscilla.
Good evening, Khadija. Thank you for having me.
Thank you for being here. This is an interesting show because this is our 10th episode, and for the past couple episodes, we've had lawyers come up here to advise us on various issues, but I guess tonight we kind of turn the tables on the lawyers themselves in questioning when you're engaging with an attorney and some of the issues you might face, right? So we want to start basically with how you go about getting an attorney to represent you.
Khadija, I agree with you. It's a very important show because clients come to you at a time in their lives when they are sometimes at their lowest point. Yes. Very vulnerable, yes. And when they come to you in that fashion, you want to ensure that you give them the best legal advice possible.
Yes.
When a client comes to you, there are a few things that to protect themselves they should be cognizant of. Okay. One of the first is that a client must ensure that the attorney that they're attempting to retain is actually an attorney.
Okay.
That's licensed to practice law in Belize.
Yes, okay. Obvious, but need to be stated,
yes,
right?
Very obvious. Because there are some persons in Belize who put themselves out as attorneys, and that is an offense.
Okay.
So yes. They can be prosecuted for that. But first and foremost, you find out whether or not the attorney has a valid practicing certificate.
Okay.
It has to be renewed every year.
Yes.
If it's not renewed, an attorney can be fined.
Okay.
So that's the first order of business. The second is you want to make sure that your attorney does not have a conflict of interest in representing your interests.
Okay.
So for instance, you go to your attorney to deal with a land matter.
Yes.
And the attorney, you pay your fee and you go along and you instruct the attorney and tell him or her what your issue is, only to find out a month or two down the road that the adverse party or the party on the other side
yes.
had come to this very same attorney with information. And then, there can arise a situation where this attorney has instructions or is helping another client with the same issue.
Yes.
So the second thing to determine is whether attorney is conflicted.
Yes.
In a large firm where you have perhaps 7 or 8 attorneys, a conflict test will be done to ensure that there's no conflict between that potential client and an existing client or a previous client.
Yes.
And then, of course, you have to determine the issue of costs. Any attorney-client relationship whatsoever should start on a clear understanding of what the cost will be to conduct your matter. Whether it is a fixed fee arrangement, whether it is an hourly rate arrangement or a contingency arrangement, which means a percentage of any collections, that should be clearly determined up front. Yes. And trust me, the relationship will be better if these things are discussed up front. And then a retainer agreement, whatever costs you decide to pay your attorney, you should have a clearly written retainer agreement outlining what those costs are. And you shouldn't leave the office without it. Yes, the arrangement. Yes. And then something that a lot of clients don't consider is if the attorney is a sole practitioner, there are certain special things you should think about.
And sole practitioner means you're not attached to a firm?
Yes, it means essentially that I am in the business by myself. I have no other partner, no attorney.
Okay.
If the attorney is a sole practitioner,
yes.
God forbid something happens to the attorney, and normally the Bar Association would step in to take certain steps, but if there's a sole practitioner, you want to ask that sole practitioner, what steps have you taken to protect me in the event that, God forbid, something should happen to you.
Okay.
If I have deposited, for instance, money in escrow,
Yes.
I have deposited $50,000 to buy my piece of land to build my dream home.
Yes.
And my money gets tied up in your estate for a year or two, I mean, that's not something that's beneficial to anyone.
Yes.
So that is, again, something that should be considered up front.
And I think the last topic you touch on in what you should ask the attorney is something very important, because that's something actually I would never think about asking the attorney, if something happened to you, what would happen? Are there any other questions that you should prompt your attorney to answer, maybe before you actually say, all right, I'd like you to take my case and I want your services?
Well, attorneys have a code of conduct that governs their behavior.
Yes.
And to a large extent, that is to protect the attorney and the client in the way the relationship is managed. So those 5 things that I've pointed out, those are the major things that you should discuss with an attorney once you're thinking of retaining that attorney to conduct some legal service for you.
Okay. And I want to go back to the agreement.
Yes, the retainer agreement.
Specifically the fees. Is there any set fees that attorneys should charge you? How do you know if an attorney to charge you properly for their services, basically?
Well, that's a very good question. Under our legal professional act and our code of conduct,
yes,
it is expressly stated that the fees charged by an attorney to his client must not be unfair and must not be unreasonable.
Unfair or unreasonable?
It must not be unfair or unreasonable.
Okay.
And there are guidelines.
Okay. Yes. I hope so.
I know you thought that was very vague, right?
Yes.
No, there are guidelines.
Okay.
Insofar as the guidelines in the legislation, it
yes.
pretty much says that if your case is novel, for instance, there's something that's a legal issue that's going to be dealt with, has never been dealt with in Belize before.
Okay.
If it's a very difficult, complex case, the value of the claim has some say in what is a fair and reasonable fee. So there are different parameters, different things that you have to look at to determine whether a fee is fair or reasonable. And you might again say, but that is still kind of vague for the normal person out there.
Yes.
There are, customarily, there are set fees charged by attorneys. And the best thing for a client to do is to check with more than one attorney.
Shop around.
It's like when you are doing purchasing any major item. When you're buying a house, you will look at different homes and you will look at the prices and comparables and make a decision. With an attorney, you want to, of course, get an attorney of your choosing.
Yes, yes.
But there's nothing wrong in going from one attorney to the next and saying, look, I have a land that I want to transfer, and what is the fee that's going to be charged for this? Invariably, the attorneys you go to, each of them will say 2%. Of the land transaction, because that is customarily the fee that is charged in Belize for land transactions.
Yeah.
So you will find that you go to maybe 3, 4, 5 attorneys and you see everybody is saying 2%. Yeah. That is a good indicator of what is being charged in the market.
So you get a pretty good idea to judge more or less what is there on the market, the price that you should be receiving for certain types of things. But as you say, if the case is very complex, if it's something new, then you really face varying charges.
Yes, you find that mostly with litigation.
Okay.
For instance, a simple breach.
And by litigation, I just want to bring down that term.
Court.
Court, people, court.
Sorry about court. So, for instance, you have a simple breach of contract matter. You go to court. You had an agreement with somebody, they didn't abide by their obligations. So you want to sue them for breach and maybe damages. They didn't transfer a piece of land to you, or they didn't give you something they said they would give you.
Yes.
It's a simple breach of contract matter. Everybody would, quote you a reasonable fee for that, of course, as they should with all fees. But for instance, another issue may be somebody wants to litigate on copyright infringement.
Yes.
There's not a lot of litigation in Belize yet
on
copyright infringement.
Yes.
You probably have maybe 4 or 5 cases at most.
Okay.
Maybe it will entail a bit more research
Yes.
to get to understand the area. Maybe it's a complex matter. Maybe it's a matter that is worth $5 million. So the value is very important to do the research and make sure that you represent your client well.
Yeah.
So it is a balancing exercise. But again, I would advise anyone
Yes.
trying to get an attorney to assist them to shop around.
Shop around. And you expect that I'm speaking with an attorney for the first time who you're thinking of being a prospective attorney, you can negotiate, can you?
Some attorneys will negotiate, some will not.
Okay.
Some will say, this is the fee that I charge for this service because I know what the work entails.
Okay.
And I won't bring down my fee because this is what it costs to do this work.
Yeah.
Some will negotiate, and I guess it's a decision for you to make.
Okay.
Based on the reputation of the attorney, whether they're known for doing good work, etc. Yes. Whether you wish to retain that attorney or whether you want to negotiate a fee with another attorney.
Yes, yes. Thanks, Priscilla. We just have to take a very short break and then we'll be right back. Good night and welcome back to Know Your Rights. I am your host, Khadija Usher, and we are here with Priscilla Banner discussing your engagement with attorneys. We had a very good introductory segment on fees, and there's just one more question I want to lay out when it comes to fees, and because it was asked actually twice on the Facebook page in terms of the divorce rate, how much it is to process a divorce.
Well, customarily, the rates that are charged differ based on whether it is a contentious matter or a non-contentious matter.
And I need you to explain them there.
I'll break it down. So what that means is that, I'm not sure if you're aware, but Belize is a fault system, yeah. Which means that in order to obtain a divorce, there has to be adultery, cruelty, abandonment, etc.
Some reason, yeah.
So if I wanted to file a divorce petition, I can file it, and the respondent may not want to appear and respond. They may say, I'm just not going to appear, and the person will proceed with the petition and will be granted the divorce. Okay. That is an uncontested divorce. So there's nobody coming to court and say, I object to this divorce.
Yes.
They just let it proceed. Such a matter would range, at most should be $2,500 Belize dollars. $2,500. It could be less, depending on whether or not there's an arrangement, right? Yeah. If it's contentious, it would probably range from $5,000 to an upper amount, but that would be based on the complexity of the matter, whether there are a lot of property issues involved. But essentially, non-contentious, there's no respondent coming to object, is normally $2,500, and contentious would range from $5,000 above, depending on the complexity of the matter.
And we have a lot of speculation concerning when payment should be done to attorneys, in that we've received a lot of feedback that attorneys won't start working or providing their services until you give them an upfront payment. Yes. But the problem is you give them an upfront payment and you don't hear back from them after that. Yes. So is it necessary that you have to give this payment to secure the services?
Yes, you pay the funds because you're entering into a contract with the attorney. Okay. So the payment makes that contract binding. And it's a retainer that is ordinarily accepted by attorneys at the beginning so that they can have funds on account to file documents, to pay for the services rendered, etc. Okay. But there's a solution to this. Yes. It's a contract. So if your attorney takes your money and doesn't provide you a service, your attorney has breached that contract. Okay. Your attorney has an obligation under law to ensure that once he or she takes money from you, they must perform the work. And if they're not performing the work, then there are avenues that you can take to redress that. Okay, and so we could continue along this path of neglecting
the case, as some of the clients might say, as well as some might say them abandoning the case after a while. In terms of these claims, how do you go about making a claim against an attorney?
Well, ordinarily, there's a structure in our legal profession act and code that allows you to make a complaint against your attorney if your attorney has taken your funds, for instance, and hasn't done your work. There are certain provisions outlined in the code that state that you can file a complaint with the body is called the General Legal Counsel.
The General Legal Counsel.
Yes.
Okay.
And the council has as the chairperson the Chief Justice of Belize. He's the chairperson of the council. The Attorney General is a member of the council.
Yeah.
And then there are members appointed by the Bar Association and members appointed by the Attorney General. And that body sits and determines complaints that you make against attorneys.
Okay.
And they actually write decisions, and they give decisions. And those decisions would either be a reprimand against the attorney for failure to conduct work. It could be a fine.
Yeah.
The attorney could be removed from the role of attorneys.
Okay.
Call it disbarred.
Yeah.
So, and that has happened in the past.
Okay.
The attorney can be removed with conditions. For instance, they may order his removal with conditions, meaning that he must first complete your work. But there are several things that can be done to address the situation. The General Legal Counsel has written many decisions. The orders that are actually made by the council are filed with the registry. So under the law, they're supposed to be filed with the registry.
Yeah.
So as a citizen, you can go to the registry and upon payment of a prescribed fee, request the right to see the orders that have been made by the council regarding disciplinary action taken against attorneys.
And can you file this on your own? Or is it that I have to go to find another attorney to go after my original attorney?
Well, the Bar Association of Belize has taken conduct or charge of this process.
Okay.
So essentially what you do, you visit the secretary of the Bar Association, Ms. Leslie Mendez.
Ms. Leslie Mendez.
Yes, and you visit her, and she has the forms ready. She has the form for stating what the complaint is, and then you will fill out an affidavit. And what she will do is to help you to draft your complaint. It's very brief. You sit with her, you draft it, and she sends it to the General Legal Counsel. When the bar members change, there's another secretary appointed. You can call any attorney and ask them who is the bar secretary, and they will direct you to that person, even when there's a change. In fact, retainer agreements should, in practice, they should have the name of the bar secretary in that retainer agreement and her phone number.
This is the original agreement you make with the attorney when establishing fees and other obligations and duties.
Yes, and that agreement should pretty much say, if you have a complaint against me, you have a right to complain to the General Legal Counsel. The secretary of the council may be reached at this number and whatever address. So that should be contained in the agreement. Okay.
And I want to come back to matters of claim, because a lot of people are questioning, okay, do I really have a good claim? Is it a justified claim in that, for instance, you paid the attorney, he executed the case, but you felt that there was just an incompetence in his execution. You feel you earn some sort of refund? Is that a justified claim to take to this body?
Well, there are two things I didn't mention. There's a General Legal Counsel, but if your attorney is guilty of negligence, professional negligence, then you can actually file a civil claim against that attorney, and that is where you will need the assistance normally of another attorney. Okay. I know you had another segment regarding laypersons filing their own claims, and you can. Yes. But in a case such as this, I would recommend that you get an attorney to assist you with a professional negligence claim. Back to your question, some people might feel that they weren't really satisfied, and the complaint against the attorney, it cannot be just a feeling of dissatisfaction.
Okay.
It has to be one of the items outlined within Part 7 of the code.
Okay.
And that part deals with restrictions and it deals with mandatory provisions, which essentially means that those provisions, when you look at them,
Yes.
you can file a complaint for misconduct against an attorney if it falls within one of those provisions. For instance, there is a Rule 65, that says if your attorney collects money on your behalf,
Okay.
that attorney should pay your money over to you
Yes.
as promptly as possible.
Okay.
So if your attorney has collected money on your behalf and you see 1 week passes and then 2 weeks and then 3 weeks and you're not getting your money,
Yes.
that would ground a proper complaint to the General Legal Counsel for you to get your funds very quickly.
Yes.
So it should fall within the legal profession code.
Okay.
Invariably it does.
Yeah.
I mean, but this general feeling of dissatisfaction
Yes.
may
Yes.
not cut it. But if you give me more specifics, okay,
Yes.
why are you dissatisfied? Did your attorney take your money and not show up to any of your court matters?
Yes.
If so, then that is covered by the code.
Okay.
Did your attorney, let someone file a default judgment against you?
Yeah.
And now you have to go and try to set this aside, then that falls there
Under
if your attorney has
Yeah.
been delinquent in executing his duties.
And let's foresee that we have an attorney here who has had disciplinary actions taken out against him in his history. You're coming now to him as a new client. Do attorneys, are they obligated to disclose to you that they had disciplinary actions taken against them, especially if it's in the area of your issue? Is that something you should ask them about or they should disclose to you?
I think it's an excellent question. I think any client
Yes.
is at liberty to ask any attorney,
Yeah.
have you ever had a disciplinary action filed against you?
Yeah.
And I think they're obligated to say whether or not they have had some action filed against them.
Yeah.
And you should be very specific. This is a
Yes.
land matter. Have you had any disciplinary action filed against you?
Yes.
If so, I would like to take a look at that to determine and be properly informed as to whether I want you as my attorney.
Yeah.
So while an attorney doesn't have a legal obligation to sit there and say, before you retain me, I should tell you
Yes.
that I've had 5 disciplinary actions filed against me, you are hiring this person to provide a legal service to you.
Yes. Yes.
Or for you. And you want to ensure that this person is not only qualified but competent.
Mm-hmm.
And that means that you are quite right to ask whether or not disciplinary action has been filed, and it may very well be that isn't a deal breaker.
Yes.
But it also may be that will help you make a better decision as to
Who you go with at the end of the day.
Yes.
I like this topic. I like turning the tables around. But we have to take one more short break, and when we return, Priscilla will be answering some of your Facebook questions. We'll be right back. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Priscilla Banner, and we're discussing your rights when engaging an attorney. We thank you for your questions and comments on Facebook. We have selected 2 of your questions to ask our guest attorney. The first is from Liddell. Liddell wants to know if monies can be retrieved from a lawyer who is taking your money and not doing anything. Is there provision in the law for this when there is evidence? And I think we went into it a little bit, no? But
yes, it is the very same procedure. If your attorney has collected funds from you,
Yes.
that attorney is obligated to perform legal services for you. And if your attorney isn't performing those legal services, then you can just request the return of your funds. If the attorney refuses and you feel that you have, if the attorney hasn't earned those funds, then you can also file a complaint for the return of your funds on the basis that those funds were paid and no services were performed on your behalf.
Okay.
If it's, for instance, if it's a civil litigation court matter and it's ongoing,
Yes.
and your attorney has done certain things, but there are things that are left and there are funds that have been paid in, you can have your attorney provide to you what is called a bill of costs.
Okay.
And you can ask the court, if you want to, move on to some other attorney, you can ask the court to assess the bill of costs.
Yeah.
And assess the bill that has been provided by the attorney, so that the court can determine whether those fees that were charged were reasonable.
Yes.
Right? So that is a procedure that you have in the court itself, to have the attorney itemize every single work done and what was the cost for each service provided.
Yeah. It's interesting because we received a question that a lady said she has been trying to transfer land with the assistance of attorney for the past 10 years now and has seen no action really. What would you advise? Because 10 years.
Yes, well, I don't want to be taken to be giving legal advice, but I can comment on the matter, which is 10 years is an inordinate amount of time for a transfer to happen.
Yeah.
It seems to me that there is some missing key.
Yeah.
Is it that the property is encumbered and cannot be transferred free and clear, and the attorney is trying to remove encumbrances or covenants or whatever? Is it that there is some difficulty with the title? Is there a dispute between more than one person regarding ownership of the land? It could be a number of reasons.
Yeah.
If none of those reasons exist, though, and if it is the case that the attorney has just sat on the work, 10 years to me appears to be an unreasonable amount of time for a transfer to be effected, especially if you've paid for your service already. So in my opinion, if I were in that situation, I would certainly get back my papers from that attorney and take it to an attorney that I feel would do the job quickly.
Yeah.
And that is mitigating your issues, right?
Yes.
You're trying to get it done. So you take it to another attorney, and if you feel that you still want redress against the attorney that has not done well by you, you file a complaint with the General Legal Counsel.
Yes, and we went through the procedures for the complaint, so now she knows exactly where to go.
But I must say that no client should sit down for 10 years while an attorney is sitting on his or her transfer.
Yeah.
And that is one piece of advice I want to give to all clients.
Yes, yes.
You should be aggressive with your attorney.
Yeah.
You are paying this person for a legal service, and most of the attorneys I come in contact with do provide excellent legal service. And there's an attorney out there that will provide you excellent legal service.
Yeah.
So don't sit back for 10 years hoping that your attorney who has not done something for 9 years will do it the 10th year.
Yeah.
The minute you see 3 to 6 months pass and you haven't had any result, you take action.
Yeah.
You get your work done, whether you have to take it to another attorney, file a complaint. You have to be proactive as a client.
Yeah.
You know, you have rights. If you have questions, you ask them.
Yeah.
Right? So I would recommend that you be proactive and you take control of your matter.
Yeah, and I'm sure that's very important for you as an attorney. I mean, from a personal standpoint, that there are other attorneys out here who are, when you say misconduct or acting irresponsibly or inefficiently with clients, and you would like that the clients would bring this to light. That would actually really help your profession and people who are out there actually trying to do a good job, you know.
Exactly.
Yeah. Our second question comes from Yesenia. Yesenia asks, what is my recourse if I paid for a divorce 8 months ago and the lawyer has not called me as yet?
Yes, as a client, you have access to your attorney. You're paying for that access and that legal service. So I would advise Yesenia to pick up the phone and call her attorney.
Yeah.
There might be a very valid reason why it has taken 10 months or 8 months.
8 months, yeah.
It may very well be that they're unable to serve the respondent.
Okay.
In Belize, for instance, we still have this old system whereby you can get a divorce in Belize if the male is domiciled in Belize. Perhaps the male is domiciled in some other country.
Okay.
So there can be many reasons why it has taken 8 months.
Yeah.
But I want to stress again, the important thing is for the client to be proactive.
Yes.
Attorneys have your best interests at heart, generally.
Okay.
That is my experience.
Yeah.
But they do get tied down in court.
Yeah.
It's not an excuse.
Yeah.
But this is why I recommend be proactive. Go and find out what's the issue. If you can't get them by telephone, you go to the office. Attorneys should, as a general rule, it is under the code of conduct, they must return your phone calls.
Okay. Yes.
Yeah, they're obligated to return your calls. They're obligated to communicate with you.
Yeah.
They're not obligated to answer a call from you every day.
Yeah.
No, they're not.
Okay.
But they must communicate with
Communicate and inform.
you. Yes,
Very
about
good.
these things. So I would recommend that she contact her attorney and find out what is the problem, because
What's
there
going on.
may very well be a legitimate problem.
Okay. Yeah. Very good and very important advice for the client. And we have, unfortunately, come to the end of our show for tonight. Thank you, Priscilla, for joining us and providing important information on tonight's topic. Next week, we will be joined by attorney Lisette Stain, who will explain your rights when buying or selling real property. Tonight's episode of Know Your Rights repeats at 1 p.m. on Sunday on Channel 7, and it will also be available for viewing on Facebook and YouTube. Thank you for watching, and good night.